Good morning, everybody, and welcome to this program. It's a hard knock life for us. I'm really delighted to introduce our panel, and I know we'll all learn a lot. We have with us today Sixth Circuit Court of Appeals Judge Richard Griffin. Judge Griffin also served for many years before he was nominated and confirmed to the Sixth Circuit and the Michigan Court of Appeals. So he brings a wealth of experience to us. We have Justice Megan Cavanagh, who has been on our Michigan Supreme Court for several years and worked for many years, as I know many in our audience knows, as an appellate lawyer practicing in appellate courts in the state. And Chief Judge Pro Tem Stephen Borrello, who is from the 4th District Court of Appeals on our Michigan Court of Appeals and has served on that court for many years and will share his perspective, as will all our panel. So let me dive right in. You know from already that the materials, there's a link to materials in the chat room, and I want to particularly thank Judge Griffin for sending a series of tips that are really useful. There are several law review articles that we thought you might find useful, and I want to thank Elizabeth Parker, who is the program chair at the Michigan State Bar Appellate Practice section, who I've been working with in planning this program. She prepared a bibliography on advocacy that has a list of books, all of which I have in my library and regularly return to when I'm trying to remind myself what I should be doing and what I shouldn't be doing. So with that introduction, let's dive right in, and we're going to kind of go through various points in the life of an appeal, and our panel will tell us what we should avoid doing so we don't irritate them, and in the process of that will be helping us know what we should be doing. We can start with the initial considerations of the various courts. And so in some kinds of appeals, the initial question is, are you going to get into court at all? And I thought we could turn to Justice Cavanagh to share a few thoughts about getting into the Michigan Supreme Court and things not to do and to do in that part of an appeal.
Sure. Thank you, Mary. Thanks for having me. Hello to everyone. Happy to be here. So talking, obviously, yeah, that's probably the biggest hurdle for the Supreme Court, right, is how to get in, how to sort of catch the attention, or getting either oral argument on the application or getting us to grant leave on something. And I think in general, probably the biggest thing for an appellant, right, is to get across, write your application in such a way, get across the issue, the point that resolution of this case will have implications outside of this case, right? Like that this is, that it's bigger than your case. That's obviously what probably the biggest thing that we're looking for. And I think on the flip side, as an appellee, you wanna do the opposite and say, nothing to see here sort of thing. This is very fact specific. It's not going to have ramifications outside of this case. So a couple of those things.
It really bothers me that
a couple of those things that sort of help or go to that of like how to get the point across that this case has other implications. Obviously, published Court of Appeals case opinions are going to have an impact on, not just this case, but the next 100 cases. That's something to stress. If there's confusion in the lower courts or, problems with sort of practical application of existing cases, or that this case will present that, this case will cause confusion. I think a couple other things that help get that wider interest or something that we should look at. Sometimes that's hard on like a legal reform issue, right? Where you're asking us to either decide something in the first instance or make a change to existing law is to show that it's not just you making that case. I mean, that sounds a little odd, but you know, getting amicus support if you can at the application stage, particularly on those things where you're asking us to make a change or to overrule a case or something like that. I think another important or another helpful thing in looking at is, as I always say, like, you know, being aware of and reading the statements that individual justices write in response to, you know, either denials or remands or, you know, whether they're concurrences or dissents. I think you can, or at least I hope, I mean, this is the reason why we write them sometimes, right? Is so that we can, that you can telegraph that this is an area that's of interest. You know, maybe this isn't the right case for it, but this is something that we're willing to look at. So I think sort of highlighting on those, and for an appellee, like I said, sort of do the opposite to say it doesn't have much application outside of that. You know, it's unpublished, it's fact specific. You know, there isn't any problem with the existing law being applied, you know, not just on paper, but in practice. Amicus support in support of denying leave can also be helpful. We see that less frequently, but, and I think another effective way to present the argument in appellee is saying that, you know, even if the issue is sort of attractive or one of interest, that this isn't the right case to take it up. Because while we're looking for those issues that have jurisprudential significance, it's also very important to have the right case to decide that in. And so if you can sort of focus your argument on why this wouldn't be the right case, I think that that's a persuasive answer from an appellee.
Getting into court in federal court has a whole different range of considerations. And Judge Griffin, maybe you could share with us some comments on that.
Sure. First of all, I want to thank the appellate practice section of the State Bar for putting on this seminar. I think it's great. It's very interesting too for the appellate practitioner to see the differences between the appellate courts, between the Michigan Supreme Court, the Court of Appeals for the Sixth Circuit, and the Michigan Court of Appeals. I mean, we have a lot of similarities, I think, in the practice, but we also have a lot of differences. And as Justice Cavanagh pointed out, for the Michigan Supreme Court, probably the hardest thing is really get your foot in the door. The two Court of Appeals, I mean, we have a lot of appeals as of right, although we do have some discretionary matters, particularly in habeas, to get a certificate of appealability granted is one of the areas that is important to have a good petition so you can get in on a habeas case. But once you're into the Sixth Circuit, we're a court of limited jurisdiction. So the jurisdictional statement is very important in our court. And do we have jurisdiction? Is it truly a federal question that's presented in the appeal? Do we have true diversity of citizenship? Do we have a final judgment, or do we have an exception to the final judgment rule? That's kind of the first issue that we look at, like, do we have jurisdiction of the case? So I think in my court, that's very important to have your jurisdictional statement thorough, have it comprehensive, have it persuasive, so that we can decide that we have jurisdiction. And our court has an obligation to independently assess whether we have subject matter jurisdiction, even if the parties don't even raise it. So in the Sixth Circuit, be careful on that. Make sure that the jurisdictional statement is there and is thorough and comprehensive. And then I would also say for our court, the statement in support of oral argument is very important. The Michigan Court of Appeals, my understanding, still routinely grants oral argument if one side demands it. We had that practice in the Sixth Circuit until about when I got on the court in 2005. We were 2 years behind our docket, and at that point, we really had to have reforms as to how we could make the court more efficient. And one of the reforms we did was to have the judges evaluate the cases in advance to determine whether oral argument was appropriate or not. So the judges on my court, about 2 months before the case is submitted to oral argument, get together, we review the briefs, and we make a decision whether or not to schedule cases for oral argument or not. And in that regard, our rules require that if you request oral argument, that you must have a statement in support of oral argument and explain to us why oral argument would be warranted, would be helpful in the case. And that statement is very important, because when we're reviewing the briefs 2 months in advance, we look at that statement and we evaluate based upon that statement whether we think oral argument would be helpful or not. So in my court, pay particular attention not only to the jurisdictional statement, but also to the statement in support of oral argument. So that's one difference we have, and Judge Borrello can probably say what's important for the Michigan Court of Appeals.
Exactly. And Judge Borrello, I know Michigan has a rule that allows an application for leave before the appeal of right is taken. It strikes me that what the court might grant or deny on is sometimes a little bit different than what the Supreme Court might be looking for. I don't know what your view is, but I think our audience would love to hear your thoughts about the kinds of leave apps the court is likely to take or not take.
Thank you, Mary, and to Judge Griffin's point and Justice Cavanaugh's point. I can't believe this many people would come and hear me speak. I screenshotted it to show my wife, and she'll just say, well, it was because of the other two judges. But I'm honored to be here with one of the lawyers I thought was a premier appellate lawyer, now Justice Cavanagh. And I think we're very fortunate to have her on our Supreme Court, and one of my actually dear friends, and really my mentor, although he wouldn't admit it. When I was on the Court of Appeals, a colleague who reached out and was a great assistance to me, Judge Griffin. So I'm actually honored to be here. To your point, apps for leave are I want to tell you, it's the Wild West. There's really no rhyme nor reason to it. You never know. Some judge may want to say, may say, hey, I think this issue needs to be looked at. Oftentimes we get reports on these cases, and the report will say, well, even though the judge made a mistake, we don't need to grant the application because it'll all sort of somehow come out in the wash, which I can assure you most of us, if not all of us, don't subscribe to that. So I would say, firstly, if there's a profound error that's so easy, even I can see it, we're going to grant the application, and we're going to try to correct the error prior to trial. If it's something where you're asking me, hey, we don't have a case on this particular subject matter, and we would like some direction, that's more of a pragmatic approach, even, believe it or not. And it becomes very difficult because if you're coming to us at that stage of the proceedings, we don't have that much of a record. So it may be that we want to hear the issue. We think the issue is worthy of being heard, but we also need to have something on which to base a decision. So that's just the tip of the iceberg. There are hundreds of other examples that I won't bore everybody with, but essentially those are primarily the two. We see two areas. We see them more than anything in domestic relations cases. Obviously, a lot of people, the minute they get an adverse ruling, they want to come up and fight it. And again, absent real clear error, we're probably not interested in getting involved at that stage.
Thank you. Maybe we can now talk a little bit about framing issues, and I don't want to just start with the same jurist each time. So Judge Griffin, maybe you could share a few thoughts on how to frame issues and that general subject.
Sure. I think it's important to frame the issues fairly and objectively without slant or bias. You want to establish credibility in your brief. And if you are really biased in your presentation of the issues, the judges are going to discount that. And I think if you're more fair and objective to frame it fairly, the judges are more likely to decide the case based upon the way you framed the issue, and rather than to rephrase the issue and to redo it. So I think that's important, but I think that's also part of brief writing, that in your brief you want to fairly present the facts and the law, that if you misrepresent the facts or misrepresent the law, the judges are going to find it out. We all have law clerks, we have research tools. You're not going to get by, and you're not going to pull it over on the court. So be fair about the record and the law. And if there's adverse authority, you are ethically obligated to cite that adverse authority to the court. I don't think there's anything worse than attorneys not citing cases that are adverse to you, because it's unethical and also diminishes your credibility. I think the brief writing also ought to be respectful of the lower court. Even when you're the appellate and you say the judge made a mistake, you don't you want to be respectfully disagreed with the ruling below, and also you want to respect your adversary as well. So I guess the question was framing the issue. I think framing the issue, it's important to do it fairly and objectively, and that's what I would recommend.
Judge Borrello, do you want to add, amplify, disagree? What would you say about framing of issues?
I agree wholeheartedly with Judge Griffin's analysis. I always refer to framing as a catcher in modern baseball who tries to frame the pitch for the pitcher, and that is to give the umpire, which is what we are, a look at the pitch in such a way at the end so that it looks like it came directly across the middle of the plate. Now, that means you've got the corners to play with, and you've got these, you have some room to sort of wiggle room. But to Judge Griffin's point, and it cannot be overstated, if you do not state the issue fairly, if you do not state the issue in an objective basis, if you go after the judge or you go after your adversary, we're not going to give you're just probably not going to get a good result. That's all there is to it. And just to pick up on one other point that Judge Griffin brought up, there are a lot of eyes on every paper that's filed in an appellate court. There in our court, and I can't recall how the Sixth Circuit does it, but in our court, chances are a central research attorney has looked at it. three chambers clerks, attorneys have looked at it. 3 judges have looked at it. So to Judge Griffin's point, if you think you're going to get away with something, you're not. And again, I can't understate it. Your credibility means everything. I mean, there are going to be arguments that you're going to make to me where you're going to ask me and my colleagues to maybe go out on a limb. If I don't believe that you have, first of all, the intellectual capabilities of going up to Justice Cavanaugh's court and making an effective argument, in essence, making us look bad, like, you dummies, why did you do this? I'm not going to rule for you. But if you are a lawyer that is misleading, is disrespectful, there is no way you're going to get me to exercise my discretion in your favor.
You know, can I follow up on that question? Because this is something I'd like to think never comes up, but I know it does. And I've had cases where I've seen it. If a lawyer on one side is, I'm not talking about some minor misstatement that somebody in the rush of getting an argument delivered or brief written, but when there seems to be a concerted effort to obscure, to dissemble, to be inaccurate in ways that you think might help your case, the lawyer on the other side has a problem figuring out how to address that without stooping to the level of name calling. And I wonder if all 3 of you could share your thoughts on what's the most effective way to deal with that.
I will say, I don't know that I've seen it so much from being on the bench, but as a practitioner, I always called it sort of a passive aggressive approach. I would sort of frame it, and depending upon, how blatant it is, how big of an issue it is, that sort of thing. I wouldn't do it just to do it. I think it's important to sort of hold your fire on that, unless it really actually matters, right? Because otherwise you lose, I think, some credibility for that. But I always thought it was somewhat effective to sort of say, almost like, there's so many inaccuracies or misrepresentations or what have you that like sort of like I can't spend all the ink on this sort of thing, but let me highlight just a few that show, and pick the ones that matter the most or that are the most sort of readily apparent or that sort of thing. I think it sets the tone for saying, to the reader of like, all right, like I can see those, especially when the ones that you cite are pretty evident or easily ascertained. Then the ones that you're like, well, is this or is this not? You've already sort of tipped the reader to at least questioning or finding their representation suspect. So I wouldn't do it, as a matter of course, in every brief. I wouldn't do it on something small. If it's a single, misrepresentation, I wouldn't say that there are a ton of them. I'm only going to point out a couple of them. So be honest in how you call it out as well. But I think that sometimes rather than, dropping, having 81 footnotes by the time that you've gotten through your facts section because you've dropped a footnote every time to point out where that's wrong, you're losing your audience on that way too. So I think it's sort of a subtle art to point it out in a way that highlights it without, without sort of going down that path yourself.
Yeah, I agree with Justice Cavanagh on that. I think sounds good.
Yeah, I would agree. In fact, Justice Cavanagh, in one of her last arguments to me, was an appellee, and the appellant. I'm not going to talk about that other case, but I'm on. I did bad by Justice. I'm going to spend the rest of my life regretting that. But this particular attorney had thought that it'd be a good idea to attack Justice Cavanagh personally in a number of ways. And that didn't go over well with us at all. And I think by the time the justice got up to make her argument, she merely just said thank you, because we had let this individual know in no uncertain terms that you ever do that again, we're going to hold you in contempt.
Well, these are good tips for us all to remember when we're trying not to irritate the court that's going to decide.
He
our
also,
case.
just for the record, Judge Borrello moved me to the end of the call to give me the opportunity to try and settle the case, which is every appellate attorney's nightmare, right? Is at oral argument to try and settle a case, because you don't know if you have authority, you don't, all this sort of thing. But to his credit, he was doing it for the right reasons. It didn't settle, but anyway, it all worked out.
I'm ordering a copy of this tape.
Well, so let's talk a little bit more about briefing. There are so many different articles, books, comments that we could make about briefing. So I'll just leave the question very open-ended, and you can all speak about things in a brief that really bug you or cause you to start skimming or stop reading or throw it down in frustration because they're not there, or because of the way they're there. I leave it that open-ended and ask you each to share your thoughts.
Okay, I might start here. One of my pet peeves is a statement of facts. Some attorneys just like to put into the statement of facts the chronology, the entire chronology of the case. That this case started with this or that, and they go through the different dates. And so much of the chronology is not relevant to the issues in the case. And you know, some background information about how the accident happened and this and that is probably useful, but to go through every detail of the case and all the discovery that took place, I mean, sometimes the statement of facts just run on pages and pages, and a lot of it is just totally irrelevant. So I would encourage you to have a shorter statement of facts, have what the relevant facts are, and a summary of kind of the background or the overview of it. But having a boring statement of facts to start your brief, it doesn't really help. We want to get to the meat of the case. I mean, we're all busy judges and justices, and you know, we want to get to the point, and then get to the issues. It's important for you to preserve issues for your client, that you know, the arguable issues, you have to raise them to preserve them for later appeal or if the law changes. But also the issues, emphasize your best issues first and spend the time in your brief on your strong issues, and the weaker issues, put them in the back. Make your weakest issue your issue number 5, 6, or 7, and don't spend a lot of pages on a weak issue. I mean, raise it and support it, but spend your time on what you think are the winning issues. And it's amazing how sometimes I see briefs that they seem to spend time on losing issues at the front, because I don't know, they think that's the chronology of the way they came up in the trial or something. No, put the winning one in the front. And the same thing in oral argument. At oral argument, preserve all your issues, but argue the best ones and spend your time on what you think may actually win the case for you. So I guess that's my advice on that.
Yeah, I will say, I think similar along those lines. I always think of it in terms of, you know, like what Judge Griffin was referencing with regard to having, you know, like a factual dump as opposed to the relevant facts. You know, just dumping all the facts into the section, I don't think is effective. But I always look at it as, you know, the best briefs sort of tell the story. I think a big part of it is you have to figure out what your story is. It may be factual, but a lot of times, especially up in front of us, it's the procedure, how it came in at trial. What did this do? That's not always sort of chronological, but know what story you need to tell, and then to make your point. The best brief sort of get you hooked. You're on the right sort of landscape, and then you get to the issue, sort of along with the writer. I think that those are probably some of the most effective briefs. I think another thing to think about. I always say, or I try and do this when I'm writing opinions, but I think it's true with briefs, and it's also how I edit my high schoolers writing assignments in English classes, like that phrase that you're not done when you don't have anything more to say. You're done when you don't have anything else that you can remove, that you can take out. And it's harder to write less. It's harder to write more directly, but it's much more effective that way. So just like filling pages and using big words and including, all sorts of cases, 5 case sites where one will do, more isn't always better in that regard. I think I will say some of the things that I really do find helpful. I think a strong introduction is very important. I think that's true also at oral argument. It's obviously a little different, but where you say what the issue is. I mean, yes, in the issues presented, less is more. Again, being more precise is better. But sort of giving the reader a path of, this is where I'm going with it. Setting that up, I think is very helpful. And like I said, I think it helps at oral argument too, of saying, this is what I plan to cover, until, all the judges derail you and you never get past point 1 or something like that. But so I think that's very helpful. Certain things I really like, and I've noticed, I think other people do this, but I noticed it most often with the Attorney General's briefs. When they file, they have right up front a section, a reference for all the statute, like with the full statutory language that are relevant and are going to be discussed in the brief, and it's sort of one of those things that I didn't even know I liked until I started reading them that way and saw them. And then when I see that I don't have it and I have to go figure out where it is, it's very, I think that's very helpful. Along those lines, and sort of along this, like telling the story and sort of setting up an introduction, and that it's very frustrating to sort of get a brief where you feel like you're just dropped into the middle of it. Without the sort of context, because then you're forcing your reader to go and do the sort of, background and figure out, how do we get here and what is all of this? I mean, I know that in some ways, maybe we're to blame, like when we order, when we have a MOA, right, or a mini oral argument on the application, and we ask for supplemental briefs, and we're like, don't repeat everything that was in your application. There are a couple that like take it very literally, like where it's like you have no frame of reference of what you're even talking about or where we are. It's like, just it's not effective. You don't want your reader to have to do more work. You don't need to repeat everything, but obviously as skilled attorneys, how to get the important points across, even ones that you have included in your application, without repeating it verbatim, but giving enough context for how to read that. A couple other things. I do find it's very helpful, like if a map or a photo or a timeline or a chart, the engineer in me loves a good flow chart. If anybody's got one of those, if it's important to your case, like put it in the brief. Incorporate that in. I think that's very helpful. Along those lines of like putting the statutes up front. Anything to make it easy, if it's going to be important and it's going to be something that the reader is going to have to look at multiple times, right, to understand some of these things, then make it easy for them. I'm trying to think. And for us, I think a big part too is what's so critically important is the relief that you're requesting, which is also, or largely comes up to us as a preservation issue. You know, a lot of times, or many times, you're asking, or the parties may be asking us to do something that you haven't asked the lower courts to do. You know, whatever, you should have had summary granted in your favor, and now you're asking, well, actually remand it for an evidentiary hearing or something like that. And that's fine. I mean, your argument may change up and down, but recognize that, I think, sort of be upfront about it. If you have an issue with that, and give us at least your best take on a path for how you can, you know, that relief is still actually an option, or how we could get there to actually get the relief that you're asking us to do. Because a lot of times that's a problem, and that sort of goes back to some of this, that maybe this isn't the right case for it, right? Because it hasn't been preserved, or it's you know, they didn't want a Daubert hearing, and so they never asked for it. And yet, so if that's the only relief that we think would be warranted, then this is probably not a good case to give it. So that's sort of my
Judge Borrello, I'd love to hear your comments on that. And one of the questions from our audience related to inconsistencies and inaccuracies in the briefing is whether, how helpful are the commissioners or central research staff in pointing out those kinds of inconsistencies? Is that something that they ordinarily pick up on and alert you to, or not?
Well, the short answer is yes. It is something that they bring to our attention, and I will tell you, they're usually very giddy about bringing it to our attention. They sort of live to find mistakes and say, look, we found this mistake. And I think to that point, and this of course gets back to my colleague's earlier remarks, with a statement of facts, I'll just tell you what I do. I'll read your statement of facts, but I've been burned so many times by relying on attorney's statement of facts. I'm going to rely on my commissioners to tell me what the facts are. So yes, they do point out inconsistencies. We will talk to people about that at oral argument. But the only point I want to make, and I would encourage everybody to look at the materials, particularly the materials that Mary wrote and the one and what Judge Griffin has provided, because it really does just kind of give you everything you need to know. But, you know, years ago, I remember, I think it was Clinton was running for office, and they couldn't keep him on message, and they would always say, it's the economy, stupid, just remember it. Well, in my opinion, in appellate work, it's the brief. The brief is the document that I live and breathe with, that I have right here by my side, and I get to see that for a lot longer than I get to see you. So the brief is far more important, in my opinion, than is oral argument. So if you don't say it in your brief, or you think, well, you know, I don't really have time to write a good brief, I'll just make up for it at oral argument. By the time I walk out on the bench, 90+% of the time, I've got a fairly good idea how I'm going to resolve that case. And that's before you open your mouth. So I'm just trying to alert everybody that the brief is very, very important. It is important to be fair, as Judge Griffin and Justice Cavanagh pointed out. It's imperative that you grab my attention. Remember, you're talking to three people that I tell people, what do? You know, that when you're appellate judge, unless you're on the Supreme Court, nobody knows what an intermediate appellate court does. And I just say, well, I basically read War and Peace every day. And if I don't read it today, I got to read it twice tomorrow. And we read an inordinate amount of material. So to Justice Cavanaugh's point, if you can put a map in or anything that's going to help me, give me a quick frame of reference, the use of the statutory guidelines, or statutory language, which the AG's office does an excellent job of doing. Again, that's all helping me because I don't have to, you're not making me flip back and forth between, portions of your brief. Another thing that is imperative that Judge Griffin points out in his writings is if it's a particular area of law, like a public service commission or workers' comp or tax tribunal, or something that a lot of us don't have a lot of experience in, don't write your briefs as if you're trying to put it into workers' comp today. As my father told me when I first started out and I had to write my first brief, he said, write it as if a second grader can read it, because that's who's going to read it. We call them judges. But I think it is important that if you're in these very, specialized fields, and increasingly this is true, lawyers have a proclivity of talking to one another. Well, that's great if you guys want to chat with each other, but unfortunately, neither of you is going to be making this decision. So if you're talking over my head, which granted isn't hard, but if you're talking over the head of your audience, that's ultimately going to, has your fate in their hands. How smart is that? So that's another point that needs to be emphasized. And also to another point that Judge Griffin made that I want to just say, and then I'll be quiet, but this is a pet peeve of mine, and that is proofread your materials. Proofread your materials. Now, I brought this example. I'm not going to say who it was, but I had a case not long ago, and I got it here. And this was the first sentence in the brief. And the issue was dealing with some easements and things of that nature. But it says, and I'm not going to even say the community, this community struggled to become one of the most affluent communities in the state of Michigan. In order to effectuate that goal, they barred blacks and non-Gentiles from purchasing property. Now, I don't think that's what the attorney meant to say, that he felt that it was a good idea to bar people of color and Jewish people from owning homes, and that made you. But if that's the first sentence, and that's what I read, it's very difficult for me to get back to the second sentence. And at oral argument, when I asked, hey, is this what you meant? Instead of saying, oops, it became very defensive. So again, just to pick up on the points of my colleagues, take your time, put every thought you can muster into that brief. Give yourself enough time to do it right.
Let me ask a couple of other questions, picking up on some of the points you've all made about briefing, and then we'll move to oral argument in a few minutes. One is just a quick little technical point. You were talking about don't include things that aren't really relevant to the specific issue in the statement of facts. One of the things that comes up when I send briefs to clients sometimes, I try to avoid dates unless it's a statute of limitations or dates are particularly important to the issue. So I say a few weeks later, John Jones went to the store or whatever it is. And then my clients redline it and they want me to put the dates back in. So I'm hoping you can share your thought about dates in factual statements and other kinds of precision when it's important and when it's not, so I can discuss it with my clients when they're redlining my briefs.
Yeah, I'll say, I mean, the trick is always knowing, I mean, it's needless dates, right? if you're talking about, filing an NOI and, when the statute ran and that sort of thing, obviously the dates are important. If you're talking about, the day that on such and such he testified in his deposition, blah, blah, blah. I mean, it's not necessary. I think it's helpful, again, sort of along the theme of like telling a story and bringing the reader along, that using some of those different transitions as you're talking about, a couple weeks later, 1 month later, whatever it may be. I think just for readability, for helping sort of understand, I think you tend to, you just keep seeing dates over and over and over again in your head. You're like, I'm probably supposed to remember these, and why am I supposed to remember them? And then you're not, and then you've lost the point of what comes after the date because you're focusing on the date. So I think that's actually a very good style. And as far as like telling clients, I mean, a lot of it is setting the expectation. And I know, Mary, you do this and have and most of you do, is like, you just have to sort of set the expectation of like, look, I know this is how the court views this or things. I always thought like as far as like granting agreeing to STIP to do extensions or something in the Court of Appeals or something like that, is setting that up from the beginning of saying, look, this is my practice. This is how I do it. If they ask for it, we're going to give it. This sort of thing, sort of setting that expectation is always helpful to do. And yeah, I mean, and saying, look at, this is, I think I'm trying to keep them engaged in that and follow along with lead them to where I want them to be. And therefore that's why I don't do it that way. But
Yeah, I would agree. I mean, if the date is not relevant, don't put it in there. If the time is not relevant, this happened at 2:10 p.m. Well, so what? I mean, if the time and the date doesn't matter, the brief, if it flows better without it, I mean, don't put it in there. Also, brief writing, if you can be more precise in your writing, the better. I mean, a 40-page brief may be more persuasive than an 80-page brief. And don't think that you have to use the entire limitation to be persuasive. That things that are said well, you can say it shorter and more precise. And so I would say, yeah, don't include irrelevant facts, dates, and that kind of stuff in the brief.
yeah, I was going to say, I borrowed this from my one of my kids' freshman English class, like a way of editing, and like,
Yeah.
And they did it like each day, which was super helpful, but like, a different technique each day. But having them separated out is going through and removing modifiers, going through and removing particular legal writing like the heretofore or wherein after or whatever you may do, taking the transition words that are 3 words and finding a more plain language single word to get that point across or that sort of thing. I think is really a helpful process, right? Removing modifiers, removing repetition. That I think I think it's totally like understandable in human nature, particularly when you're trying to write a piece of persuasive writing, that you're going to be repetitive in some respect because you're trying to get it's just sort of human nature, and that's all fine. But the editing process has to happen where you go back and you're like, I don't need to say it again. I just said it at the beginning of the paragraph, that sort of thing. So that process, again, when you're done, when you have taken out all that you can take out.
Yeah, if you've said it well the first time, you don't have to repeat it, and try to write it well when you first do it, I think.
So maybe we could touch just for a moment before we turn to oral argument on questions about judicial philosophy, policy arguments, areas in which you're addressing a legal point on which you know that the court before which your case is pending has judges or justices with divergent views. How would you suggest we approach those kinds of issues in the briefing process? Or do you have thoughts about that?
Well, I think it's obvious with our court, right? Because you know who you're writing to, and all 7 of us decided. I think you don't know when you're writing your brief in the Court of Appeals which panel of judges is going to be deciding your case, right? And we can talk about it oral argument once you know your panel and doing that sort of research about those particular judges. But I'll say, like, you know, calling out justices or their position in other cases is done all the time. I think personally for me, I think it's fair game. I think not only current judges or justices, but also former justices and where the sort of decisions fell and, you know, who was in the dissent and who was in the majority and why was that? And, you know, how did that change over time? I think that that's part of, you know, the fabric of arguing in the Supreme Court is, you know, who the 7 are, you know, short of being brand new to the bench, you have opinions and, like I said, statements, which I think we all secretly believe that, like, people should read them, but we think that nobody probably does read them but we keep writing them anyway. Particularly the legislature doesn't seem to read. We think they should, but I don't think they really do. But so I think I think it can be used effectively. And I think that part of that is just being upfront about it, of saying, look, I get that, you know, whether this is the majority opinion, you know, and this has been the prevailing law, and I'm agreeing with it. And I understand that there are, you know, there have been, and there may still be a contrary viewpoint. But address why you don't think that, you know, should change or whatever it may be. So I think with us, when you know who your bench is, I think, and like I said, I think we're somewhat unique at the briefing stage to know who it is that's going to be deciding it. I think that that's fair game, and I think it can be used effectively.
Yeah, you know, in our court, you don't know who the judges are when you do your briefs. So I think you've got to draft your brief for everybody, and you make arguments for maybe more of the liberal judges. This is one argument, and then for the more conservative judges, you make another argument. You make them all, and in the alternative, if you don't agree with this, well, you should rule for me for this reason, and or the third reason. I mean, you make all the arguments so you cover all the bases. I think that's what you've got to do, you know, in our court. Then when you get down to oral argument and you know who the judges are, you research their opinions, their writings, and then you can focus on what approaches you think would be the most persuasive for those 3 judges on the bench. But the brief in general, the first brief, you've got to do it for everybody, and I think you got to throw it all in there, all the arguments.
Judge Borrello?
Yeah, absolutely. Same as Judge Griffin said, you got to cover the waterfront, so to speak. And you know, this concept of policy to me is a non-issue, because as I view the law, all law is policy, and all policy, the law is imbued with policy. So you know, every once in a while we'll get a lawyer who will say, well, this is a policy, and policy belongs in the legislature. And, you know, be careful what you say and what you write, because as Judge Griffin and Justice Cavanagh pointed out, it might not be, you might turn somebody off just with a simple statement like all policy matters are matters exclusively within the purview of the legislature. So to Judge Griffin's point, yes, you should write a brief so that, the liberal wing of the court and the conservative wing of the court would both find something that they can hang their hats on.
Yep.
So I'm thinking about the sort of outer parameters of what you can put in your brief in terms of policy arguments. And I think, Judge Borrello, you made the point all law is policy. And I think good briefs articulate the policy underlying contract common law, or the policy that underlies some legislative enactment. Some briefs seem, though, in some arguments, to just be saying, well, this is really an unfortunate thing, or I'm not articulating the question well, but I know there's some outer limit there that we probably don't want to go beyond, or some qualitative difference. And I wonder if you have thoughts to help us define what that limit is, or parameter between a proper argument about policy in the law and a sort of non-legal argument that's not going to be compelling to a judge.
Well, some of the greatest briefs in history were little light on the law and long on the policy. So there's certainly been throughout our history, with Oliver Wendell Holmes, among others, that have written these phenomenally moving briefs based solely on policy. Obviously we're guided by stare decisis, we're guided by constitutions, we're guided by statutory provisions. So I don't know if you can reach, if there is an outer, somebody had to come forward at some point in time, just in our state's jurisprudence, and say, this comparative negligence stuff, this is not good. And here's why it's not good. We should really implement a system where we say that open and obvious is controlling. And these are the policy reasons behind that. And a group of jurists bought that policy argument. And it was the law in this state for a good many years, until recently, when our Supreme Court said, you know what, we've looked at the policy underpinnings of this argument. We don't feel that it comports with the law, but we also don't feel that it fulfills its policy statements that we were led to believe it would. So you're always going to want to push the envelope if you're the person who's trying to change the law. And I think you do that. And the only thing what I would say that you would not do is just don't be offensive about it or high-minded, or, but certainly I encourage lawyers. Listen, let me say this before I forget. I read briefs every day that I think to myself, if you put me in a room with a typewriter or a computer for 100 years, I would never come up with this. I cannot tell you how many phenomenal briefs I've had the pleasure of reading in my 20-year tenure, not just blowing smoke. I'm sure Judge Griffin feels the same, and so does Justice Cavanagh. So I think if you're a good lawyer, and most of you are, if not all of you, of course, everybody here is a great lawyer, but use common sense. That should define the parameters.
So
yeah, I guess I would say, just adding on to that, I do think, I'm not sure how to define the parameter, but I think, rather than this is just the way I think it should be. You're not doing a very good job being a lawyer if you can't say why or what supports that, right? And to support your own argument, but to convince somebody to adopt it. There are all sorts of policies underlying common law. We have all sorts of ways of doing our best to discern what the policy is behind any kind of legislative act. The context, the language of a preamble, the words chosen. We have all of these things that I agree, it's not so easily divorced to say this is policy and this is law. And there would be very little, I think. I mean, I think if all you're saying is, I get, yes, everything is going the other way, but I just don't think, I think it shouldn't be that way. I mean, it's not convincing, I mean, what do we don't get to write opinions that just say, well, this is just what I think it is, although maybe some people think we do that, but not always, right? I mean, I think that I think the limit is that if you can't offer some support for it, then it's a policy argument that you just don't have any underpinning for.
So moving to oral argument, one of the questions from our audience is one that I'm going to direct to Justice Cavanagh, because I know she's thought about it, and that is, does oral argument even make a difference?
I 100% think it does. And I know that I maybe I'm in a minority, but I knew this was always, this was always the debate of the two central debates as an appellate attorney. Does oral argument matter? And should you put citations in the body or in the footnote, right? Like, these are the great debates of all time. I am a in the body person. I do not like footnote citations. And it was very gratifying to me from my own experience to see that oral argument really does matter. It matters for me, and I see it matters for our court. I have, and I think part of the reason why is it's a difference in the process, right? Like, as an attorney, by the time you get to oral argument, you are at basically the end of your process, right? You have like known the record all that you can. You've made every argument. You have written it 8,000 times by the time that you get to the Supreme Court. You have put it all out there, and you are like, here you go. This is what I've got. This is the best. And for us, it's definitely not the end of the process. It's about the middle of the process for us, right? Because we still have to figure out what we're writing and how we're writing it and whether to write this. I never thought I would spend as much time as I do deciding what not to say, and what not to decide. Then I decide what to say. But so for oral argument, for me, it may not necessarily change the outcome, may not change my mind of, I came in as a reverse and now I'm in affirm or deny or something like that. But I would say at least half the time it changes, or it influences how we decide it, how it gets written, sometimes whether it's an opinion or an order. So the nuance of it, and because I think a big benefit of oral argument in our court is, yes, the brief is critically important, and we've read it multiple times, and multiple people have read it, all these things that we're saying, but oral argument is sort of like the time to, like, to me, is like, how does this work in real life? What's the greater context of it? What's the real world application? Is this bigger than this? Is this actually this big issue? Is it going to affect other people? What's the rule that you want? I mean, that's always I think that's the, $1 million question in our court is, what rule do you want us to say, at the end of the day? And that's why I think the most sort of effective use of they call it free fire. It should be fire free zone, right? Fire free zone, 2 minutes of fire free zone. Use it. It's there for you, or waive it, whichever it is. But I think the most effective use of that is, give us the rule that you want. And then also, but right at the beginning, give us the roadmap of where you're going. And the rule is the end result. Because if somebody's going to ask you that generally. So if you sort of get out in front of that, now, then when 7 people are talking at you and trying to pick that away of like, well, is that really the rule that you want? What about this? What about this? But I think that's where this gets fleshed out. And that's how we where we decide cases is how much do we say, how much do we not say, do we say anything at all? And oral argument helps us flesh that out. So I think it absolutely matters. I know it has absolutely influenced my decision. And I will say, if anybody else in my course says it doesn't influence them, I would say they're not being truthful. But because it does, it shapes the conversation, it shapes how an opinion gets written.
Yeah, I would say on my court, I'd say oral argument makes a difference. I'd say in one or two cases on every docket, every week that we have oral argument, and it may be that one of the judges is undecided as to the result of the case, or it may be that one or more of the judges are undecided as to the rationale of how to decide the case. And as Justice Cavanagh said, the give and take at oral argument really flushes it out as to not only how it ought to come out, who should affirm or reverse, but on what basis to come out, how broad of a holding we should have. Should it be a narrow holding or should it be a broader holding? And so, yeah, as a practitioner, I would say you don't know if you are the one or two cases that really will make a difference in oral argument. So as a practitioner, I would recommend that you ask for oral argument, that you try to get it, and you show up there and you argue vigorously in support of your case. One point I'd like to make, that if you're arguing and you can tell that the panel is in your favor, that it really appears that you've won the argument, you don't have to keep arguing. You don't have to use your full 15 minutes. You can let the judge's comments just settle in and say, well, unless you have further questions, I think I can sit down and save my time for rebuttal. I've seen attorneys just want to keep arguing even after it was kind of obvious that their point was meritorious, and all of a sudden the judges will come up with something else, and maybe you might end up losing the case by continuing to argue something else, or anyway, another issue might come up. So I would say if you're winning, sit down and just shut up and take your victory. But I would say demand or request oral argument and be prepared for it.
Judge Borrello?
Yeah, just to pick up on the latter point of Judge Griffin, and I know, Mary, you and I have looked at each other on a number of occasions when I've told the lawyer you're going to win, and they just keep going, and it's mind-boggling. And so, I mean, how stupid, and sorry to be that way, but my goodness, when a three judges basically telling you you're going to win, shut up and sit down. And you'd be shocked at how many times it doesn't happen. But to the core of it, does it matter? Well, of course, oral argument matters. I mean, I don't think any judge or any jurist would tell you that it doesn't matter. I think the issue, and I agree with Judge Griffin and also with Justice Cavanagh, is what effect does it have, or what's the impact of the oral argument on the case as a whole? Even if I've made up my mind what I'm going to do, a lot of times, if I'm gonna rule in your favor, I may really put you to task to see, all right, do you really, is this as it seems to be? If I'm not going to rule in your favor, I'm likely to say, well, what about this, where I see the weaknesses in your case, or the places where I think you're wrong? I'm going to want to explore those. So I think, yes, I mean, it does matter, and I think that my colleagues are right. You should always ask for it. But know this, I mean, we're sitting there and we're hearing a lot of different arguments about a lot of different cases, about a lot of different issues. And I think the one cardinal rule that I would say above all others is this: oral argument is not for you, it's for us. And I think if you keep that in mind, you'll be a much better and far more effective oral advocate.
One
Yeah,
point,
Oh,
oh,
sorry.
go ahead.
No, I was just gonna say they reminded me of like the best advice that I got when I was arguing is that you need to figure out before you go in there what is your weakest point and how you can not necessarily concede, how you can acknowledge, how you can address it and still win. Like you need to figure out that argument. And there were always certain judges on the Court of Appeals where it was like, if you don't answer that question, they are done with you, like, and so no, that's the most effective oral argument, because really, like, that's also how the judge is thinking and writing a decision, right? Is how do I acknowledge this? Because we do have to acknowledge, the hard points in our opinions as well. So help us get there of why you still win.
See, I think that's a great point. The judges, when they ask questions, you should encourage the fact or that the judges are asking questions, because they're interested in the matter they're asking the questions. So answer the question. One of my pet peeves is when I ask a question and I get an evasive answer that's not responsive. And sometimes I'll ask the question again. I said, maybe you didn't understand the question. This is that, and then they'll answer something else, and that is not helpful at all, to be evasive. And for attorneys to have candor, and as Justice Cavanagh stated, to admit maybe the weaknesses of your case, and that's not my strongest point here. I mean, it's very helpful, and getting the conversation going back and forth with the judge or justice, I think is really important. And to do that, answer the questions, please. That's why we're asking them.
That is, let me just chime. That is absolutely, hands down, other than lying to me, the most frustrating part of the job is when you ask a question and the lawyer just refuses to answer it. It's just, I really want to jump over the bench and hold you down and say, answer my question. Because I'm asking it for a reason.
One of the things that surprises me watching oral arguments when I'm there for cases of mine, and it probably doesn't surprise our panel because they see it every day, is how often lawyers appear flummoxed by questions. And it is anybody who has practiced appellate law for decades will have a time when they're going to be asked a question that they don't know the answer to, or their answer is not as precise or as well formulated. And you have to figure out some way of gracefully trying to give whatever thought you have or explaining your view. But one thing that I think we can all do, I'm just offering this, is to do a better job of anticipating what the questions are going to be. And I think our panel could talk to us about the kinds of questions. And I would also say some of the books on appellate advocacy, David Fredericks is one, and there are others that I think are in our bibliography, there's chapters listing types of questions that you might get. So I often go back and try to remind myself of all the types of questions I might get, because it's easy when you're in the middle of a brief to be thinking of the things you think you need to address and missing a whole universe of other things. With that sort of intro, maybe you could each share something about the nature of questions that we should be anticipating, or any thoughts you have to help us with that part of our job.
Well, Barry, I don't think there's anything wrong with an attorney saying, I don't know, in response to a question. You say, well, how do you distinguish this case from 1885. There's nothing wrong with the attorney saying, I'm unfamiliar with that case, Your Honor. I'll be glad to get back with you with some supplemental authority after oral argument. But I don't think you have to think that you have to know the answer to every question. You can be honest that, I'm just basically unfamiliar with that, but I'll get back to you, Judge. That's fine too. That you want to anticipate as much as you can what's going to happen, but when you really are taken by surprise, be honest, I think, rather than make up something, I guess.
Yeah, and I'd say in our court, I think the most important sort of questions to anticipate is, like I already said, it's like, what rule do you want? But I think beyond that, you need to anticipate the why. Why is that the rule, and where did that come from, right? Like, why is that factor, should be included, and why not this, or what have you? And then the sort of outer bounds of your rule, right? Like if you can't answer beyond the facts of your case, that's going to be a problem, because that's not much of a rule, right? So, and again, and it sort of gets back to this, like, I think that there's nothing wrong. And in fact, I think it can be very effective to be able to say, no, I don't think, if the facts were as you've just sort of outlined them for me, we all know they're not the facts of your case, right? We're testing the rule sort of thing. Then no, I think that would be a much harder case, or that one I think would clearly fall outside the rule, and here's why. So I think coming from us is knowing the rule, the why, and then how far sort of on the limits. And I don't think that there's any problem of sort of saying, like, I'm not sure on that one, like that one gives me pause, or I'm not sure what that is. And that's not arguing other people's case, or these other sort of win beyond you. Like, we all know why we're there and what the facts are of your case. We're trying to figure out the rule.
I think great arguments are like great jazz solos, having the ability to think quickly on your feet and to improvise. And also, to my colleagues' points, but always with great candor.
We have a little bit of time left. If our audience has questions, please do put them in the chat, and we can ask those. But in the meantime, I wonder if we could ask each of our panel to say what might be, without identifying names, sort of the worst argument and why it was so bad, or the argument that irritated you the most, and what the advocate did that really lost your attention, lost credibility, lost whatever they were trying to do.
Yeah, I'll start. I don't know that it was like that I can pinpoint one particular argument, but I have, and I hate to sort of do here are these things that bug me, or the pet peeves, because and maybe because having been there myself, like it's a lot. It's intimidating. It's nerve-wracking. It's a lot of work to get there. It's a lot of work to stand there for what can feel like an hour and a half or 5 minutes, right? And so I'm always like, I don't think that there's any problem in letting us know, this is my first argument, or I'm really nervous, let me start over, or maybe I misspoke. Like, no problem with that. But certain things that I think are ineffective, moving around a lot like around the podium, is very distracting. That's some people's style, right? I tend to talk with my hands. I know some people find that distracting too, but I remember, and I forget even what it was, like literally jumping from side to side on the panel, like trying to make a point. I think even though it's a lot that you're trying to sort of keep together and keep on track, and then, field questions and not try and interrupt and all of these things, you need to sort of take some of the nonverbal cues, like if you see us leaning forward because we can't hear you, or and even ask, like, are you hearing? Are you struggling? Do I need to move the mic up the podium or what have you? I think that just sort of being aware of that, of your volume, your speed. I think, just sort of inherently sometimes we're like, what, like if you can't hear you, or if it's sort of overwhelming. The rolling your eyes or sighing and like in response to your question is really ineffective. I also sort of find it a little cloying when people are like, you know what, thank you, that's a really good question. It's like, okay, like, I mean, anyway. So just sort of the style, like being direct and that without sort of telegraphing that you think we're an idiot for asking that question is not super helpful. And the other thing I will say is exhibits. I have never seen them used successfully in our court. It doesn't happen very often. I think I saw a question in the chat about with trial attorneys. I think when they do get used in our court, it does tend to be trial attorneys who do that. And they're, I think, effective only if they can be, not distracting. And I've never seen them be not distracting. There's just not a good way to display it to 7 of us in our courtroom. We don't need the language of the statute on an exhibit. I mean, we get that sometimes. Now, obviously there are, exceptions to it, like, but again, put it in the brief, right? And then go off of that. And if it's in the brief, then if you're trying to track, like, here's the timeline of how this happened and what the witnesses said, and this is why this evidence would have made a difference, on retrial or whatever it may be. But putting it as an exhibit on display in the courtroom just is not, I've never seen it being done effectively. And another little tip, one last tip on the Supreme Court, the shape, this is something I learned, the shape of our courtroom, if you are sitting in the back or near the back and you're whispering, it comes around the side. So we can hear you on the ends as clear as day. So just FYI. It's like you're sitting next to us. Yeah. So
well, that's interesting. I would say, make sure you begin your oral argument correctly. I mean, when you rise, the first thing you should say is, may it please the court, and be acknowledged by the Chief Justice or the Chief Judge. But start out by, may it please the court, then introduce yourself, that I'm attorney so-and-so, I represent the appellant so-and-so. There may, often in appeals, there are multiple appellants, there are multiple appellees, and just don't assume that we know, 1, who you are, and 2, who you represent. So identify yourself and tell us, who you represent. I also, for practitioners, I would say, if you have a sympathetic client, bring your client to court and introduce your sympathetic client. I mean, if you represent an insurance company, I'd say don't bother. But if you represent somebody injured in a wheelchair or something, that, got run over by a bus, have your client there. And I would say, if the court allows, have your client at the counsel table. At the Michigan Court of Appeals, we used to allow it, and I've allowed it at my court when it's been requested, but it's been requested very few times. Finally, I guess we're talking about the worst oral arguments. The worst oral arguments in front of me are when we ask a question of the attorney, and the attorney says, the question relates to the record, lower court record. Well, didn't defense counsel fail to object to this at trial? And then the defense attorney on appeal says, well, I don't know, because I wasn't the trial attorney. So I can't answer that question about the record because I wasn't the trial attorney. Well, my response is, well, where is the trial attorney then? Why isn't he arguing on appeal? Because I want somebody here that does know the record, that can answer questions that are record based. And when you have an attorney on appeal that doesn't know the record, well, I mean, this argument is worthless to me if you don't know the record. The final point is, know how the court is run. The Michigan Supreme Court know how the Chief Justice runs the time clock. Is the Chief Justice going to be very strict with the limits? So when your 30 minutes is up, you're cut off at that time. We've had judges on my court that when that red light is on, you're out of there. But we also have judges that are very liberal with the time, that the red light is more of a suggestion that it's time to wrap up. But know how the presiding judge runs the court, and you can kind of adjust your argument a little bit, and at least finish your sentence or finish the thought that you've got. But anyway, those are the final points that I have.
Yeah, real briefly, just to touch on what my colleagues have said. I was in court just last month, and the lawyer walked up to the podium and he said, "How y'all doing today?" And that was his opening
Yeah.
statement. And I said, "Holy smokes, did I land at a Cracker Barrel, or am I on the Court of Appeals?" And hopefully got the message across. That's not the way we do it. But it is an issue, and I don't mean to be the guy screaming about kids on his lawn, but it seems to be prevalent, I would say, among newer lawyers, and that's discouraging to some degree. You know, just to end it for me on this is that, candor is greatly appreciated. Listen to the questions, answer them to the best of your ability. We want to write the best opinion we can, and we're relying on you to some degree to help us write that opinion. So when we do ask a question, please give it some thought and answer it. If you can't answer it, I absolutely agree. I don't know. And there's nothing wrong with that. But above all else, you may think I'm the dumbest, who ever walked the face of the earth. And I probably wouldn't disagree with you, but I expect you to respect the position that we hold. And that's starting to become an issue, which is really sad to me as well. Be honest, be precise, be thoughtful.
Well, those are great words for us to end on. We had some other excellent questions, and we could obviously spend hours talking about this topic that's so important to our process. But my computer clock is telling me we have reached the end of our time. I want to tell you that the materials were posted. There's a request to repost them in the chat. I'll make sure that they are. And if for some reason you have trouble accessing them, please let me know, and I'll make sure that you get them. I want to give a deep thanks to our jurists who've really done a wonderful job in talking about our advocacy, and thank them so much for their time and sharing their insight with us. And with that, I think we're done. Thank you all for coming.